Hi, I'm Stephen Woodworth. I'm the Member of Parliament for Kitchener Centre and also the mover of Motion M312 in Parliament to study Canada's 400-year-old definition of human being. And today I'd like to speak to you about the history and implications of Canada's definition of human being. So I want to thank you today for taking the time to listen to this video, to watch it, and I want to honor your gift of attention and time with my gift back to you of some information that I hope you'll find useful. I'm confident that you're watching this video because you're searching for answers, and I'm also sure that you're searching for justice, if you're like most Canadians. So here are some of the questions that I hope to answer for you. Does Canada actually have a written down definition of a human being? And what's presently required by Canadian law to be considered a human being? How old is Canada's definition of human being? Why is a definition of who is a human being so very important to our law? What exactly am I asking Parliament to do about it? And most importantly, what can you do about this? And what can you do to make a difference? I'm often reminded of a story of two fellows in the early days of air flight who were experimenting, and they decided to go up in a balloon and they raised themselves, and after a while they couldn't control this thing anymore and they drifted and they looked down. They didn't see a landmark or a river or a mountain that they recognized, but they did see a fellow down below walking on a path. So they lowered down to them and they hollered down to him, "Where are we?" And after a moment of thinking about it, he hollered back up to them, "You're up in a balloon." And as they were floating away, one fellow turned to the other and he said, "You know, that guy must have been a lawyer because everything he said was perfectly true but also totally useless." So I'm hoping today that the information I give you will be a little more important and helpful and useful than that. Let's begin by thinking about what obstacles prevent us from finding the answers that we're here to seek. What obstacles stand in the way of justice when it comes to the rights of children before birth? Well, isn't it because too many Canadians are reluctant to even talk about such issues? How can people search for answers or bring justice to laws without being able to talk about it? That leads to the next question. Why are so many Canadians reluctant to even talk about the rights of children before birth? Well, the short answer is that too many of these conversations in the past have lacked wisdom. And by wisdom, I mean three things. First of all, to be wise, one must be truthful. Second, one must be fair or just. And third, and most importantly, one needs to be compassionate or sensitive about the subject that you're dealing with and the people to whom you're speaking. The last of these requirements is actually the most challenging. Talking about the rights of children before birth inevitably means also talking about the rights of mothers. No one should ever understate the important and sometimes traumatic effects of pregnancy and childbirth upon women. Insensitivity to these concerns leads nowhere. Insensitivity towards the interests of children before birth also leads nowhere. In other words, how we say things is just as important as what we say. So what are the consequences of the refusal to talk about the rights of children before birth? Well, the survey says only 20% of Canadians are aware that our law provides no protection whatsoever for the rights of children before birth. And of course, pollsters never ask about the definition of a human being. What they ask about is abortion. And when they do ask about abortion, 58% of Canadians say that there's no need to reopen the question of abortion. Well, that makes perfect sense once you realize that 80% of Canadians think we already have a law that does protect the rights of children before birth, at least in the third trimester of their development. Most importantly, when Canadians are told that there is no such law, that in fact there is no protection for children before birth until the moment of complete birth itself, 72% of Canadians would like a law that does provide some protection. So the details are here. 28% of Canadians say that human life should be protected from conception. 17% more would protect human life from 2 months after conception. So that's 45% up to that point. Another 17% would protect human life from 3 months after conception. That's 62%. And in fact, another 10%, although it's not mentioned here, would protect human life from 6 months after conception. So we have a total of 72% of Canadians who would like some protection for the human rights of children before birth, at least in the 3rd trimester of their development. Now, this is not an academic question. Although recognizing the rights of children before birth does not guarantee their protection, our present law does guarantee a lack of protection. Dr. Margaret Somerville, an ethicist at McGill University, did a study of some of the statistics around the lack of protection for children before birth in Canada. And she found, first of all, that the statistics are not required to be kept as to the gestational age of a child before birth at the time of an abortion, but 45% of hospitals report it anyway. And here are the results that she found just based on those 45%. First of all, there are at least 400 post-viability abortions per annum performed in Canada. The Canadian Medical Association sets viability at the age of 20 weeks of gestation. Now, 400 is only 1% perhaps of all abortions performed, but it's still a significant number when you consider that those are 400 children whose rights before birth have not been recognized. More importantly, there were 241 deaths from the years 2000 to 2005 in Canada, infant deaths categorized as termination of pregnancy, fetus, and newborn. Now, that does not include children born dead as a result of abortion. So we know that because they were classified as infant deaths, those 241 children were actually born alive, but then died subsequently, and the cause of death was listed as termination of pregnancy. So it's certainly not an academic question as to whether or not we recognize the rights of at least some children before birth. These deaths are what would be considered, I suppose, partial birth abortions, or at least, at the very least, late-term abortion. So the fact is that Canada does have a written down definition of human being which allows these kinds of things, and which allow, in fact, that children's rights are not recognized until the moment of complete birth. And here it is. It says that a child becomes a human being within the meaning of this act when it has completely proceeded in a living state from the body of its mother, whether or not it has breathed, or has an independent circulation, or the navel string is severed. Now, no one should be confused about the fact that it says within the meaning of this act. That refers to the Criminal Code of Canada, but in fact, court decisions have held that this definition applies to Canadian law generally, and therefore, until a child completely proceeds from the mother's body, the child is not a human being, and therefore no human rights will be recognized for that child, so long even as the little toe is in the birth canal. Now, recognizing the human rights of children before birth will not necessarily provide protection for them. However, we can say that limits on abortion do necessarily demonstrate some recognition of the rights of children before birth. And I think it would be useful to look at how this issue is dealt with around the world. So, in fact, in the United States, for example, there are 36 states which bar late-term abortions. In the United Kingdom, no abortions will be performed after 24 weeks, and even before that time they are prohibited except in the case where there is a threat to life or grave or permanent injury. France, no abortions after 12 weeks. Germany, Norway, the same. Italy, 13 weeks. Sweden, 18. Netherlands takes the viability route, which in Canada would be 20 weeks. None of these countries permit abortion except in extreme circumstances. So they recognize the rights and interests of children before birth, at least to some degree. There are only 3 countries in the world, apart from a few American states, that offer no protection for children before birth in the way that Canada does, and those are China, North Korea, and Vietnam. That's not necessarily the company that Canada would like to be in. So when was Canada's definition of human being written? Well, you may be surprised to know that it was written at least as early as the 17th century, 400 years ago. Here is Cook's Third Institutes of the Laws of England. I've handwritten in the 1644, for those who can't translate the Latin, MDCXLIV. And in the top paragraph, here is a photocopy of exactly what Lord Cook had to say about this question. And here is a typewritten version which is a little easier to read. And I've highlighted the important sections that relate to the definition of human being. In the 4th line down, it says, if the child be born alive, then it's murder to take the child's life, for in law it is accounted a reasonable creature in rerum natura when it's born alive. In rerum natura is a little bit of Latin. It's an old lawyer's trick when you want to confuse people, mix in a little Latin so they don't know precisely what you're talking about, but we're going to explore in a moment what that actually means. So you can look this up in Wikipedia. I don't often recommend Wikipedia, but there it is. It's a born alive rule. And it indicates that certain things only apply to a child that's born alive, and American courts have, some at least, have overturned this rule. Abortion in Canada is still governed by the born alive rule, as courts continue to hold to its foundational principles. So the foundational principles are found here. It refers to Cook once again, and the requirements of a reasonable creature in rerum natura, and also in the King's Peace. The 3rd paragraph from the bottom explains that reasonable creature actually is a religious doctrine, and it has to do with the idea that there was a rational soul. What it really means is someone capable of reason at some point. And there was disagreement about whether it occurred at the moment of conception or the moment of quickening, that is, when a child begins to move in the womb. As for rerum natura, that means that the thing killed must be part of the world of physical beings. And the courts interpreted that in the 17th century as meaning completely expelled from the womb. And finally, the thing killed must be in the King's Peace, that is, a loyal subject of the monarch. So that's kind of the way in which the Renaissance world determined who was a human being, and it's really quite unusual from the 21st century perspective. The law that a child does not become a human being until the moment of complete birth entered Canadian law from British common law, and perhaps it made sense in the days when leeches and bloodletting were standard medical practices, but the question I'm asking is simply, does it make medical sense in the 21st century? Does this law make sense when parents can watch their child sucking her thumb with ultrasonography, ultrasounds before birth? Does it make sense when doctors can actually perform surgery on a child before birth? Does this law make sense when we can actually measure a child's brain waves and count her heartbeats before birth? Does it make sense to say that a child is not a human being when her organs are perfectly formed and when we can count her heartbeats before birth? How can we possibly justify denying that such a child is in fact a human being at some point before the moment of complete birth? This is not merely an academic question. Now, sometimes people claim that a desire to recognize the scientific evidence that children are human beings before the moment of complete birth is simply a religious view. And yet, there are courts around the world who accept these kinds of medical advances. Ultrasonography, fetal heart monitoring, fetoscopy, measurement of the functioning cerebral cortex. In Massachusetts, the Supreme Court has held that a fetus does constitute a person for the purpose of vehicular homicide. In Minnesota, that has been determined by legislature. In California, also. So how can we claim that this is not a religious issue that the courts are working on? I've given you here a quote from Raymond Burke in 2009, which is pretty important on this issue, and he distinguishes between purely confessional practices, which certainly have nothing to do with politics or policy or law, and the teaching and upholding of moral law, common to all men, which it's true is at the heart of every true religion, but which is also common to everyone. So a confessional practice, for example, might be to say that everybody has to go to church on Sunday. Well, no one in their right mind would try to make a law out of that. On the other hand, the idea that we should respect the inalienable rights of every human being is something that is recognized worldwide. It doesn't matter what race you are or what religion or whether you have no religion. It's a fundamental and foundational moral principle, nothing to do with religion. So how do we determine those fundamental and universal principles of justice? Well, again, I would say that a law, in order to be just, must be truthful, it must be fair, and it must be compassionate to all concerned. Canadians know from their own experience that a child is a human being at some point before the moment of complete birth. In other words, they know that Section 223, paragraph 1, is dishonest about children before birth. When it says that a child becomes a human being within the meaning of this act when it has completely proceeded in a living state from the body of its mother, Canadians know from their own experience that this is not an honest statement of the facts. Subsection 223(1) is purely and simply a law that says some human beings are not human. And in Canada, in the 21st century, we should never accept any law that says some human beings are not human. This lesson was learned in the United States when the U.S. Supreme Court, 9 highly educated, civilized, even religious judges of the United States Supreme Court ruled in 1859 that blacks were not persons under American law. Wouldn't you and I have objected if we'd been in Congress at that time? We also learned to reject any law that treats some human beings as not human when the Canadian Supreme Court, again 9 highly educated, civilized judges, ruled that women were not persons for all purposes under Canadian law. Wouldn't you and I have objected if we'd been in Parliament at that time? Now that we've discovered in the 21st century that Canada has a law that says some children are not human beings until the moment of complete birth, why should you and I fail to object? Why is it important that every human being's inalienable rights should be legally recognized? Well, I have to tell you, it's sad that I even need to ask that question. Canadians, of all people, understand instinctively that any law that denies fundamental human rights without cogent evidence and sound principle is simply not legitimate. Would we want a Canada where any person or lobby group, simply because of their political power, can arrange a law to declare some human beings as not human simply to suit their purposes or policy or ideology. If we accept one law that says some human beings are not human, the question you have to ask yourself is, who's next? Well, that question, sadly, was answered on February 23rd, just this year, in the Journal of Medical Ethics Online. The authors of that article, Professors Alberto Giubilini and Francesco Minerva, answered the question, and they began by recognizing that the status of a fetus is, for all practical and moral purposes, equivalent to that of a newborn infant. However, they reached the flawed conclusion that a child before birth is not a person. And consequently, with impeccable logic, since there is no difference between a child before birth and a child after birth, they conclude that neither is a newborn infant a person. Well, with, again, impeccable logic, they therefore claim that killing a newborn could be ethically permissible in all the circumstances where abortion would be. And why not? If there is no difference between a child before birth and a child after birth, and a child before birth is not a human being, well then, impeccable logic, neither is a child after birth. Now, this idea pushes the envelope, and you may wonder if, in fact, I'm making it up, so I want to show it to you on the screen. They titled their proposal, After Birth Abortion. These professors, by the way, are affiliated with quite respectable universities, the University of Pisa. One of them is associated with the Bioethics Institute at Oxford University. They both teach in Australia at a university there. This is the abstract or summary of their article. I've copied it right out of the article, by showing that both fetuses and newborns do not have the same moral status as actual persons, and the fact that both are potential persons according to them is morally irrelevant. Adoption is not always in the best interests of actual people, by which they're referring to the mother and parents. The authors argue that what we call after-birth abortion, killing a newborn, should be permissible in all cases where abortion is, including cases where the newborn is not disabled. Now, reading between the lines, you would say that they definitely include cases where the newborn is disabled. Here's another statement from the body of their report. When circumstances occur after birth such that they would have justified abortion, what we call after-birth abortion should be admissible. They go on to explain why they're using that euphemism of after-birth abortion rather than infanticide. And the last sentence really drives the point home. We claim that killing a newborn could be ethically permissible in all circumstances where abortion would be. I'm not making this up. Here's their conclusion. If the criteria, such as the costs for the potential parents, are good enough reasons for having an abortion even when the fetus is healthy, if the moral status of the newborn is the same as that of the infant and neither has any moral value by virtue of being a potential person, then the same reasons which justify abortion should also justify the killing of the potential newborn when it is at the stage of a newborn. So the logic of that after-birth abortion proposal is compelling if you can accept that our laws can legitimately say that some human beings are not human. Now, the authors, just a few days ago at when I'm taping this in the end of March, issued a kind of a non-apology apology saying that in spite of what they actually did say, that this should be justified, they didn't really mean it should be justified. Well, you can take that however you wish. The fact is that even though ideas might sometimes be shocking when they're first proposed in this manner, we know from the last 20 or 30 years that we often become desensitized to shocking ideas, and before you know it, if they're repeated often enough, they seem to become more and more accepted. So this shows why the study of that idea, the idea that's in our law that says that you can have a law which declares some human beings are not human, this shows why the study of that idea is so timely and so compelling at this time, so urgently needed. I'd like to show you a statement that I made about this in 2010 in the House of Commons. And I began by pointing out that this is a matter of passionate debate on many different lines, cultural, religious, and social. But a wise man, a wise person knows that passionate debates need to be resolved. And I asked the question, who is responsible for finding resolution? And I've answered it. It's members of Parliament who should be reconciling Canadians. What I wanted to do was put across the idea that these are noble issues. Issues of fundamental human rights. Does every human being deserve the protection of fundamental human rights? Or is a child only a human being when fully born, as our law says? Is a child a human being before that? And when rights conflict, how do we balance them? These are noble questions. They deserve noble answers. They don't deserve to be swept under the carpet. And the fact is that it is members of Parliament who have the duty to lead Canadians in providing this reconciliation and answers to these questions. In fact, I want to refer you also to what a former Justice of the Supreme Court of Canada said. And some of you may be surprised to hear that these comments come from a woman with impeccable feminist credentials. And here is what she had to say. These comments were made in her judgment in the Regina versus Morgentaler case in 1988, when she in fact threw out, with the rest of the court, the abortion law existing at that time. And she said the precise point in the development of the fetus at which the state's interest in its protection becomes compelling, I leave to the informed judgment of the legislature. She went on to say that the legislature is in a position to receive guidance on the subject from all the relevant disciplines: cardiology, anatomy, neuroscience, the ones that I mentioned earlier at least. She then went on to say, interestingly, that it seems to me, however, that it might fall somewhere in the second trimester. Even this judge, a woman with impeccable feminist credentials who threw out our last abortion law, didn't agree that the rights of children before birth should be left totally unprotected. She would have thought that sometime in the second semester of their development we should be recognizing their rights. So clearly this jurist believed it was wrong to refuse any recognition whatsoever to children before birth, and clearly she felt that it was Parliament's duty to remedy that situation. And this view has been shared by other courts since. And that brings me to motion 312. It's important for you to know precisely what it says, because I regret to say those who oppose it would like to talk about everything except what's proposed in my motion. It's a little wordy, but I'd like you to take a look at it on the screen. First of all, the top paragraph is important because it talks about appointing a special committee to review the declaration in subsection 223(1) of the Criminal Code, which states that a child becomes a human being only at the moment of complete birth. It is focused solely on the definition of human being. I know that there are other questions around abortion. What happens in the case of rape? And should we make it an offense for a woman to smoke while she's pregnant? I'm not trying to answer those questions. I know there are difficulties that will be addressed in that respect, but I'm simply asking Parliament to consider the question of when a child becomes a human being. Now, the next three paragraphs are really technical questions about forming a special committee. In the bottom paragraph, which has a preamble and 4 parts, is really the most important part of my motion. It requires the special committee to present a final report to the House of Commons with answers to these questions. One, what medical evidence exists to demonstrate that a child is or is not a human being before the moment of complete birth? I'm not trying to presuppose that question one way or the other, only asking the committee to study the evidence. Is the preponderance of medical evidence consistent with the declaration in section 223(1) that a child is only a human being at the moment of complete birth? And then talking about other than medical scientific matters, in number 3, what are the legal impact and consequences of section 223(1) on the fundamental human rights of a child before the moment of complete birth? And lastly, and most importantly, what are the options available to Parliament in the exercise of its legislative authority in accordance with the Constitution and decisions of the Supreme Court to affirm, amend, or replace the subsection? I'd like you to focus very carefully on the last part that I've just shown you, which is to say that I am only asking that the committee come up with options. I specifically did not ask the committee to come up with any single preferred recommendation about our definition of human being or about abortion or about anything else. What I'm trying to do is to get the committee to come back with all of the options. We can leave section 223 as is. That's one option. We can abolish it and not replace it. That's another option. We can amend it so that it recognizes the human rights of a child at a certain point in the child's development. I simply want the committee to report back the evidence and the options. And you know what? At that point, when the report is delivered, my motion is finished and Parliament can take it or leave it. The motion doesn't require any decisions whatsoever to be made by the committee or by Parliament itself. It's really just trying to promote a healthy dialogue, a discussion, and inform Canadians about what the evidence is. I regret to say that not everyone is open to dialogue. Not everyone is as willing as I am to put their ideas to the test of evidence. I don't mind people who disagree with me. I don't mind if, in fact, it may turn out I'm wrong. If I say to you that I think a child is definitely a human being before the moment of complete birth, if the evidence says otherwise, well, that's what the evidence says. But I'm willing to expose my propositions to that test, and I would like others to do the same. Where does that leave us right now? And what can you do about this issue? Well, this motion needs to be voted on in Parliament, and I have to tell you it's far from a sure thing that Parliament will even agree to a study of this issue. It may well not do so. That's going to be up to 308 members of Parliament. And so if you think that a study of this issue is worthwhile and not really a terrible thing to get the evidence on the table, then what I'd like you to do is to contact your member of Parliament and express that point of view. In fact, if you can, you should contact all 308 members of Parliament to express that point of view. Members of Parliament really do respond to public opinion, and I know there are people out there who don't agree with this plan and who will be contacting their members of Parliament to express that point of view. So what I'd like to do is to show you some website information which will give you some of the tools you need in order to contact members of Parliament. So first of all, if you're not sure who your member of Parliament is, you can contact www.elections.ca, put your postal code in, and your member of Parliament will come up. You can also go to www.parl.gc.ca/members of Parliament, and that will give you all the members of Parliament and their contact information. Visit my website, and you'll find a number of these links. Visit the website of www.notyetborn.wordpress.com, and you'll find a petition that you can circulate among your friends and neighbors. You'll find sample letters and posters, and also contact information for members of Parliament. Now, if I can, I would gladly come into your community and provide this presentation in person. If you can help to arrange that opportunity, please contact my office. You can do that through my website. This motion is going to come to a vote either in June of this year or perhaps later in September. So that's the timeline that I have, and that if you agree with me, you have, in order to contact your Member of Parliament and all Members of Parliament in order to persuade them that studying a 400-year-old definition of human being with up-to-date 21st century medical information is a good thing to do. And I hope you'll join me in that effort, and I thank you very much for taking time to listen to this video today. Have a wonderful day.